Good afternoon, everybody, and welcome to this Global Sanctions webinar on delisting. If you're not in the UK, good morning or good evening. We are joined today by four what I would describe as battle-hardened veterans from the world of delisting challenges. First of all, we have Maya Lester-Casey from Brickcourt Chambers, described by the legal directories as the queen of the sanctions bar. She is very much sought after for sanctions advice on compliance as well as delisting. And I think it's fair to say that no UK counsel has made more appearances in the General Court of the EU on sanctions cases than Maya. Also from the UK, we have Malcolm Birdling, who's leading junior counsel. Malcolm is a public law specialist and has over the last few years developed a very strong delisting and compliance sanctions practice. He acts for both the government and clients seeking to be delisted, and he appeared in the leading UK delisting case of Schvidler and a number of other matters, one of which recently resulted in a rare delisting by the UK government. From the United States, we have two excellent speakers. The first, Eric Ferrari, needs little introduction. He's the founder of Ferrari and Associates in Washington, DC. He has many years of experience of engagement with US authorities, OFAC, State Department, US Department of Justice on sanctions-related issues, including litigating a number of cases in the federal courts. And last but certainly not least, Andrew Adams is a partner at Steptoe in New York. Andrew specializes in his practice in national security matters and white-collar crime, including sanctions. And we are particularly pleased to have Andrew on this webinar, as he was until quite recently the very first director of the US DOJ Klepto Capture Task Force, set up following Russia's invasion of Ukraine in 2022. Lastly, for those who don't know who I am, my name is Michael O'Kane. I'm the senior partner at Peters & Peters. We specialize in this firm in sanctions, have done for over 13 years. With my colleague, Hannah Bradshaw, one of my partners, we have a very active practice in not just delisting, but also compliance and litigation issues involving sanctions. So with those introductions out of the way, let me just tell you a little bit about the format. We're going to have a sort of discussion, which will be chaired by me, which will last about 45 to 50 minutes. And then hopefully that will leave a bit of time at the end for questions. We will try and choose the most relevant and pertinent questions from those that come in during the course of this discussion. And we're going to be focusing really on three key topics. And those topics are the procedures for delisting from sanctions lists in the United Kingdom, the European Union and the United States, and interactions with governments on delistings, and the approach finally of the courts to delisting. So let me kick off then, Malcolm, with you, if that's all right. I just want to focus, first of all, on the UK. And I've got a few questions for you just in relation to that. Let me just run through those with you quickly so you can have a think. So firstly, what information does a person get in the United Kingdom when they are actually sanctioned? When and how do they get that information? And then what is the process that a designated person or a sanctioned person goes through if they want to challenge their particular sanctions listing in the United Kingdom?
Sure. Thank you very much for that introduction and for those questions. So first, what do you get when you're designated? At the point of designation, you actually don't get terribly much at all. You don't get anything more than what's published on the website, which is usually just a very short narrative about what sanctions have been imposed. Your name, contact details, and a sentence or two about how it said you meet the criteria. And if you want more information, you have to make a request to the Foreign Office to receive it. To answer the next question before I go into what you get, the disappointing answer is you don't get that information immediately. And that's disappointing, really, because there's no reason why you shouldn't be able to get it immediately, because what you get is effectively the decision-making documents. That's the material that the Foreign Office relied upon when it made the decision. So there's not really any reason in principle why you shouldn't get that immediately, but sometimes it can take, you know, a month or more for that information to arrive. And that can cause difficulties down the line, because you can't really do anything to get yourself off the list unless you actually know why you're on it in the first place. So what you get when you do receive the substantive response is there are two key documents. The first is what's called the sanctions designation form, which is a prescribed form that the Foreign Office uses, which sets out, first of all, the legal basis for the designation. So that explains what boxes it is thought that you tick in terms of the designation criteria. And then you get a summary of the factual material which is relied upon and how that's said to justify the designation. And then later on in the form, you get an assessment of what the Secretary of State thinks the impact of the designation is likely to be, both on you and more generally. And then also its compatibility with human rights law. So that's the form, and that really is the key document when it comes to determining what it is you need to challenge if you want to get off the list. You also get what's called the SDFE dossier, the E there standing for evidence, which really is just a dossier of the evidential material that's relied upon. In my experience, it is always exclusively open source material. You never get closed material, or at least I haven't seen it. So what you normally get is a PDF clip of screen grabs of web pages, news articles, NGO reports, all of which the relevance of which is explained in the sanctions designation form. And then you also get, so those two documents, the documents that the decision maker really made their decision based on, but you'll also get a disclosure of decision-making documents, which can be emails between decision makers and notes of submissions that are made to ministers, which can be enlightening, but really it's the SDF and the SDFE that you need when it comes to thinking about how to challenge it. So then we come to the third question, which is, how do you go about challenging it once you've got the information? The first point is that you can't race off to court to challenge a designation in the United Kingdom. In fact, Maya and I had some recent experience where we tried unsuccessfully to get interim relief on behalf of a client who'd been designated, and the court said quite clearly that in this jurisdiction, unless or until you've made your application for a ministerial review and the minister's actually considered it, the court just has no jurisdiction to look at anything at all, except perhaps a complaint that the minister has been delaying things. So what you have to do is you have to make an application to the minister to revoke your designation, assuming that you've been designated on a discretionary basis. And what I mean by that is you're not on a UN list, because if you're on a UN list, you can make an application to the minister, but what you'll be asking the minister to do isn't to take you off the list, but rather to use their best endeavours to get the UN Security Council to take you off the list. And that's a distinction which sort of echoes down into what the courts can do. So what you're asking is the minister to have a look at it. You're explaining why you think the designation is mistaken or unlawful or wrong, or why, as a matter of policy or discretion, they ought to take you off the list. Practically speaking, the officials then sort of take it away. It goes into a black box or a sausage machine, however you want to describe it. You don't really know what's going on, but it takes in the order of some 4 to 6 months to get a decision out of the government. And then what you get really is a fresh assessment of whether you meet the designation criteria and whether your designation is proportionate. The last time I spoke on this topic, I had the rather pessimistic punchline, which is that I wasn't aware of anybody who had actually successfully been taken off the list. But happily, I can now say that one of my clients did get taken off the list in the process as a result of this ministerial review process. So it's not It's not absolutely impossible to get off the list. But if you're not successful at that stage, what you get is a decision from the minister, either leaving the designation as is, or, as is quite common, varying it to take into account mistakes that they may have made earlier in the process. So they might accept that they'd made some factual errors on the basis of the open source material, but that decided it doesn't make much difference. And then if you haven't persuaded the Secretary of State to take you off the list, you're left with the prospect of a court review, which I think we'll come on to talk about a bit later. So that's the process in a nutshell.
Brilliant. Okay, Malcolm, that's wonderful. Thanks so much. So it might be really interesting to know how the EU process is different from the UK.
Sure. So some things are the same. So when you're first listed, similarly as in the UK, you just see the published reasons in the sort of short paragraph that you see them on the sanctions list. You do sometimes get a letter from the EU authorities to your legal representative or to you if they have your address saying that you have been sanctioned. Now, when you write to, in the case of the EU, the Council of Ministers, that's the EU Council responsible for sanctions listings, it's similar. So you get a bunch of what are called working papers in the EU, which are very often, in fact, almost always, as in the UK, sort of articles, open source material, which supports the designation. There isn't really the equivalent of the sanctions designation form. I think the UK, when it was drafting its post-Brexit legislation, in that respect, sort of improved on the EU system in the sense that you do get a lot more reasoning as to why it is that the UK think that you should be listed, why they regard a listing as proportionate, as well as sort of ticking the boxes with the designation criteria. I think the key difference with the EU is that there isn't really any administrative procedure. There isn't really any engagement with the council or with, as it were, executive agencies. Often if you make representations in the EU, you will get a pretty rudimentary letter back, which doesn't really engage with your arguments. But really importantly, you have a 2-month time limit in which you have to go to the European Court if you wish to bring an annulment action. So it's not like the UK where you've got to go to the government first before you can get to court. You have to get to court. And if you don't get to court in time, you then are waiting normally another year before you can get to court. So in that respect, it is different.
Wonderful. Eric, when you hear the UK and the EU system, are you envious, or is the US system any better?
Oh, it sounds like heaven to me. I mean, there's all kinds of time limits, and it sounds, at least in the UK, so maybe there's a neutral arbiter involved in the whole process. But on the US side, it's different. As an initial matter, the designated person in the US system only receives the press release announcing the designation, and I use the word receives loosely here because it's not as if OFAC or the State Department actually sends the designated person the press release. Rather, it's published on either of those agencies' websites, and thus it's publicly available for the designated person to access if they become informed of the designation. This in the US system is what we call constructive notice. So in other words, the government publishes something on a website, then affected parties are deemed to have been provided notice. The contents of the press release, if you know how to read it properly, you can identify what the determination is. So, for example, operating in the energy sector of the Russian Federation, you can identify what kind of the conclusions are and the findings. One of the things that's difficult about reading the press release, however, is that the press releases often contain what is referred to as additional information. So if you look at the administrative record underlying a designation, and I'll get to that in a moment, there's a whole nother section which has information about the particular target, which is actually divorced from the basis for their designation. And so it's derogatory information that the government wants to put into the press release, but which is otherwise immaterial. And the reason why immaterial to the basis of their designation, and the reason why I bring that up here is because a lot of times clients or other practitioners will get confused, and they'll kind of be thrown off by the derogatory information and seek to pursue delisting and rebut the derogatory information when really at the end of the day, that's not material to the basis of the designation. Now, aside from the press release, a designated person can request the administrative record underlying the designation. So this is the evidentiary memorandum that was prepared by the sanctioning agencies in addition to their evidence in support of the findings and conclusions in that evidentiary memorandum. But the majority of that record is going to be redacted as classified or otherwise privileged and withheld from disclosure. You can request it via a direct request from the Office of Global Targeting at OFAC or from the State Department's Office of Sanctions Implementation and Policy, or via a Freedom of Information Act request furnished upon either of those agencies. The problem is these unclassified versions aren't going to give you much beyond what is already contained in the press release. And the typical wait time we've experienced has been about 18 months to 2 years from the time of the request to disclosure. So, unless the client has all the time in the world and they don't mind being on the sanctions list, which I would ask the question, why are they hiring us? They don't really want to wait around to start the process until such disclosures are made. Now, with respect to how to pursue delisting, there are essentially 2 avenues by which you can do that. Unlike it sounds, as Malcolm was saying, in the UK system, you can seek judicial review in a U.S. district court of the initial agency action, which constitutes the designation. But more commonly, there's also an administrative delisting process. I'll start with the judicial review process and just go through it quickly. The most important thing to understand there is the court is only looking at the legal basis of the designation. So the court is sitting as a court of appeal over the agency's action. And so it won't take on new evidence or new facts. It is only looking at what information was in the agency's possession at the time that it took the action to designate the party. And in doing so, it is only performing a legal review to determine if the agency has provided a reasonable explanation of the basis of its designation, which means that it's looking at whether or not there's a rational connection between the evidence in the agency's possession and the choice to designate. And the choice to designate is a determination whether or not a reasonable cause to believe exists that the party engaged in the conduct. So not that Treasury or state thinks that actually the party did it. They don't have to think the party actually did it. They just have to have a reason to believe that they did it in order to designate. In conducting that review, the court is not going to substitute its judgment of the evidence for that of the agencies, and it will provide the agency with extreme deference, those are the court's words, at least in the DC Circuit, to the agency's determinations and assessments of the evidence. And the courts have said the agency's decision does not need to be a model of analytical precision, and that the weaknesses of any particular pieces of evidence being relied upon don't matter so long as the totality of the evidence shows a rational connection between the choice made and the evidence in their possession. Last point, and not to be old man shaking his hand at the fist at the cloud here, but the courts have also found that the agency can rely on hearsay and anonymous sourcing, and there's no requirement for the sanctioning agency to verify or corroborate the evidence in its possession. So you can probably imagine I don't get invited to a lot of parties because I tell quite a depressing tale, but that's the reality of these kind of judicial reviews. So let's talk about something that's maybe more positive, which is the administrative delisting process. This is more focused on the presentation of facts. So as opposed to legal arguments, designated parties can come in and present evidence and arguments to show that either one, there's an insufficient basis for the designation, i.e. there's some mistake, legally or factual, or 2, that the circumstances resulting in the original designation no longer apply, or 3, propose remedial measures, which if adopted would negate the basis for the designation. And you would present those arguments and supporting evidence in a petition for removal. And once that's received, OFAC will send a questionnaire or a series of questionnaires, or the State Department will send their questionnaires, which are to be responded to in writing by the sanctioned parties. Sometimes, on rare occasions, there'll be an interview between the agency and the sanctioned party, where they may ask for some final clarifying information or information that is more sensitive in nature. But ultimately, usually they just review the submissions that are made and make a decision in writing as to whether or not they deem there to be changed circumstances, or if the proposal is sufficient, or in rare cases that a mistake was made. So that's the U.S. system.
Eric, thank you very much. It sounds as though there's quite a bit of, engagement in the United States. You're sitting around a table and having these kind of discussions, which is a little absent from the United Kingdom, but it's something I just want to go on and talk about a little bit now. And that's sort of the interaction that you can have with the sanctioning element of the government when it comes to kind of delisting applications. So just coming back to the UK for a moment, Malcolm, just thinking about that for a second. First of all, does the government ever sort of delist people without this process that you've described having been gone through? And does the government sort of actually engage, whether it's by correspondence or in meetings with the representatives of sanctioned people, to have like interactions on how they might be delisted?
Yeah, but both good questions. The first one, does the government ever delist without being asked? The short answer is not really. I say not really because there are examples of people being taken off the list because they've died. That's not very helpful to your live clients. But otherwise, it's not a proactive process whereby the government goes through and reviews and takes stock and reassesses sanctions as a category. That was what was intended at the time the UK sanctions legislation was passed, because what was provided for at that stage was a process of periodic review. It wasn't going to be annual like it is in the EU, but you would have sort of triennial reviews. That requirement was removed. So what you're left with is very much a reactive process whereby you make your application and then the minister considers it and decides what to do. In terms of engagement during that process, yeah, I think you're absolutely right when you suggest that is absent, and this is a situation where I think I'm slightly envious of what Eric described about the US position, because the government hasn't provided, well, first of all, the government hasn't provided any guidance as to what it will consider when it makes delisting applications. So you're left doing a bit of crystal ball gazing about what it is the government wants to see. Quite often, when you get disclosure of the sanctions designation forms that I spoke about earlier, you'll see that one of the reasons why they've imposed a sanction is that they want to encourage changed behavior on the part of the designated person. But what is absent is the government actually engaging with you as to what they would like that changed behavior to look like. Sometimes there's a bit of sort of reading between the tea leaves you can do when you get to court, because whatever evidence you'll put in about what changed behavior there's been, the government will come back and say, well, that's not good enough. But that's sort of very unhelpful because it comes at the end of the process, at a point where you're actually in litigation rather than at that early point where it actually might make a difference. There certainly isn't a process of the government saying, why don't we come in and have a chat and talk about how you can help us or what we'd like to see. I've had clients where we've made those overtures to the government and the government has just been completely unwilling to engage. They very much take the view that the process is an administrative one. You make your application in terms of the regulations, you submit your evidence, and then don't call us, we'll call you. And they generally come back when they have specific evidence that they want, usually because they think they've identified some new way of justifying the listing. But there isn't any of that sort of process of sitting around the table and looking at how the objectives of the regulations could be achieved without maintaining the designation, which is a shame, really. It just doesn't happen.
But just I think before we bring our US commentators on to that really very interesting topic and tell us whether we should be envious or not, I wondered, I mean, in light of what Malcolm has said, I mean, first of all, in the EU, there really isn't, at least in my experience, any administrative process, not least because the decision maker in the EU is really 27 member states trying to act unanimously. So there's not a great nimbleness or executive decision maker really who is set up to do that kind of thing. But I mean, Michael, as someone who has, acted for a very large number of designated people as you do. I just wondered what you thought about Malcolm's point. I mean, do you think that more interaction between the government and designated persons might be helpful if it is the case that one aim of sanctions is behavior change? I mean, so the government have said that they have a sort of off-ramp. I'm not sure if, in process, or certainly the idea of an off-ramp has been publicly stated, by which designated people can be delisted. And as Malcolm said, there have been some who have been, albeit without any reasons published as to why. I noticed one of the recent House of Lords European Affairs Committee reports has recommended that the government should sort of speak to the EU to discuss having an off-ramp for sanctioned individuals if certain conditions are met. But I just wondered whether you thought, without giving any secrets away, that designated people might be interested in, as it were, giving the government some policy wins in terms of trying to do what it is the government would like them to do to achieve their policy goals. Or do you not think that's a sort of fruitful idea, before we turn to Andrew?
Well, I mean, I would be very interested to know Andrew's view on this for reasons I'll come to in just a moment. I mean, I think one of the frustrations really is that when it comes to delisting, if we just focus, I know we're kind of covering all the various sort of sanctions regimes, but if we just focus on Russia for a second, as far as the UK is concerned, there have been 3 what I would describe as the Russian heritage business people delisted. We acted for 2 of them. I'd like to say that, obviously it was because of our incredibly powerful persuasive submissions, but I don't know, actually. I just don't know whether that was the reason or what was the reason, because as Malcolm said, you don't get any clear idea of why a particular decision, and it's a seismic decision, in this way has been made. Doesn't appear as though, and we discovered this in our litigation in relation to Mr. Schwidler, it doesn't appear as though the government has a policy as such on delisting, and I can sort of understand that, because they'd want to keep the Secretary of State's discretion as broad and as deep as possible. But where does that leave the sanctioned client? How are we supposed to advise them? Government representatives across the G7 have said now for many years that the point of sanctions is really about change behavior, but it's not entirely clear what that means. And if you look at it in respect of the kind of Russian context, what the objectives of sanctions, which changed a bit over time, but the key objectives appear to be signal to the Russian government that its actions in Ukraine are completely unacceptable by international standards, encourage Russia to withdraw, deny or reduce its capacity to prosecute the war in Ukraine, and more latterly, they've said trying to encourage the payment of compensation for the reconstruction of Ukraine. That changed behavior all seems to be aimed at Russia and the Russian government. So, it puts the sanctioned individual in quite a difficult position. What change behavior for the sanctioned individual does the government want? So an individual, and there are a number of them, they can condemn Russia's actions, they can resign, they can divest, they can orientate towards the West, but it often makes little or no difference to their designation status. In fact, the government has, in many occasions, sanctioned people after they have resigned or divested. So it's hard to know what signal the government is trying to send, because if you sanction somebody after they've divested or after they've resigned, then the signal you're sending is it doesn't really make any difference whether you take those steps or not, and that doesn't seem to me to be a wise way of approaching the issue. So I think the government potentially is missing a bit of an opportunity. There are clients who are clearly orientated towards the West, very Western facing, and some sort of off-ramp, as it's now called these days, would potentially be very helpful. But Andrew, I'd like to bring you in actually at this stage, if that's all right, because I'm very struck by the difference in the United Kingdom, the EU, and the United States. And we first came across each other when you and I had quite a long telephone call back now probably 2 years ago, when you were at Klepto Capture, and you were comfortable setting out what you were looking for as a hypothetical in terms of the steps that people ought to be taking in order to be delisted. So can I just sort of ask you a little bit about that, and about what comments you may have from what Eric has said about the degree to which there is engagement. So first of all, on the klepto capture side and when it was set up, can you talk a little bit for us about what the objective was and the extent to which you wish to encourage, and in fact did encourage, kind of proactive engagement from those who were sanctioned by the United States?
Certainly. Thank you, Michael. And thanks everybody for the invitation and opportunity to be here. I agree wholeheartedly that there is a policy on paper and a lack of policy in practice, certainly in the United States, with respect to what is expected of people who are not only on the OFAC SDN list, but on an increasing number of similar sorts of lists, whether it's the Commerce Department's entity listings, the Department of Defense's Chinese military companies. This is increasingly a normal part of any large transaction in the United States, certainly in the financial, tech, or defense sectors. I think part of that dynamic, that expansion of the normalcy of sanctions and the normalcy of these economic countermeasures, may be the normalization of the ratchet both up and the ratchet down in the midterm and long term for the United States. But it's certainly not something that exists today. That is an easy, depoliticized way of coming off of these lists. But to your point, Michael, on how DOJ, when I was there, was dealing with this in the Russian context. And let me be clear: DOJ is not the listing agency, and DOJ, the Department of Justice in the United States, is not the entity that can remove somebody from any of these lists. But in the Russian context, in particular, there was a heightened degree of interaction between and among the agencies, both in terms of investigation, in terms of sanctioning in the US, in terms of providing information to foreign partners for sanctioning abroad, and for engaging with people who wished to be considered for some sort of relief. Often that was relief in the form of avoiding sanctions and staying off the list to begin with, which requires some self-reflection and tea leaf reading by people who are not yet on the list. And in many cases, interaction by people who were on the list. Let me highlight two kinds of dynamics that I think are worth keeping in mind in that context. And this again is through the lens of DOJ and largely through the Russian context. The Department of Justice has not only policies and procedures in place for dealing with and working with people who are politically unpopular, but it is critical to the department's work. And it's something that DOJ prosecutors and attorneys do every single day. To build a big case on a cartel or a money laundering network or what have you, DOJ prosecutors actively look to engage with bad guys. They look to work with people who are themselves committing crimes, have committed crimes. It is not a political question in 99% of the cases that DOJ deals with. And civil servants, line level prosecutors are steeped in this as a process from day one to build out these big and effective cases. There are voluntary self-disclosure policies, there are corporate enforcement policies, there are deferred and non-prosecution policies, all of which are relatively transparent in terms of what DOJ wants. That degree of transparency and that sort of cultural approach just doesn't exist outside of the Department of Justice with respect to these other programs. But the interaction between DOJ and the increased interaction between DOJ and some of these other agencies, Treasury, State, Commerce, et cetera, may well be trending towards the normalization of these kinds of discussions. And effectively having DOJ as a example of the kind of transparency that people would need or want in order to get as Maya said, a policy win on at the end of the day. That is still something that's very much I think in transition, but given the expanding scope of these kind of economic countermeasures, I think there will increasingly be certainly a need and a drive to force these kind of conversations to a less politically charged level of the United States in order to get the kind of policy wins in all manner of contexts. The other dynamic that I would point to, though, is one that may press against that, and that has to do with reticence on the part of people who are listed or who may be listed to engage. And what I point to in that scenario is the notion that people understand that in order currently to engage with OFAC, to engage with state, it is different in terms of what you can expect for publicity and what you can expect for public disclosures, as compared to what you might often be able to do with prosecutors in the Department of Justice. To come off of the SDN list with OFAC often requires one, public delisting, which itself suggests that a person has been cooperative or has been engaging with the United States. It sometimes requires congressional notification, and the exact triggers for that are somewhat unclear, whether they are quantitative in terms of dollars or qualitative more generally. All of that carries real and significant risk for people from their in their home countries. Often the concern for appearing to have been cooperative, to appear as though they have engaged in a change of behavior as the result of a US economic boycott, carries significant risks physically for people, for their families, for their employees and their companies in Russia, in China, in Iran, around the world. And in my experience, that is often the dynamic that stymies these conversations, even more so than a reticence on the part of the regulators to engage.
That's really helpful. Can I just, picking up from that for a moment, it does seem as though in the United States, there's much more of a sort of overlap between the investigative prosecutorial function that you're describing and Andrew, and this sanctions de-designations, because one of the things that struck me in interacting with you is that, you know, you and your colleagues were prosecutors, and so very comfortable having the negotiations, as you describe it, with kind of bad guys. A lot of people who are sanctioned are not sanctioned for engaging in criminal behavior. Now, I know in the United States with the kingpin sanctions, a lot of those are directly engaged in criminal behavior, so you can see why the DOJ gets involved. But if you're sanctioned for being, I don't know, the former director of a Russian company, which is entirely lawful behavior, then are there then kind of limits to the extent to which engaging with the DOJ or with OFAC, and I welcome Eric's view on this as well, in terms of changed behavior, are you going to get any traction where there's no actual criminal allegation against you forming the basis for the designation?
It doesn't end the conversation, certainly with the Department of Justice. There are opportunities for people who are situated highly within certainly the Russian financial world to nevertheless provide some degree of substantial assistance or significant assistance. That doesn't mean admitting to a crime that didn't happen, obviously. And it doesn't necessarily mean providing information that will lead to additional or future charges on other people, although that's certainly what DOJ prosecutors have as top of mind. But as you say, the scope for public breaks with unpopular regimes, for provision of assistance to Ukraine or victims of Russian aggression on the one hand, of terrorist attacks on the other, are part of the larger discussion within the US policy circles about what would be acceptable. But the political headwinds are substantial, although potentially, as I say, in the mid and long term, something that may ratchet down.
Is it too early to make any sort of assessment about the extent to which the policy that was deployed by the task force, both domestically and more internationally, has been successful?
It's certainly, I mean, certainly early in the sense that these are designed to be extremely long-term sorts of economic trade policies. In the very short term, I think Treasury and state and DOJ to some extent would point to a number of policy successes, essentially in making on the Russian front, making the Kremlin's economic view substantially worse than it was previously, even if it doesn't instantly crater the Russian economy. But the kind of trade-offs, the kind of zero-sum games that didn't exist before these nearly universal sanctions on the Russian financial and military industrial complex exist much more prominently today, forces the resupply of the Russian military to be much more expensive and slow than it would otherwise have been.
Yeah, okay, super helpful. Eric, is there anything that you'd like to just comment on arising out of that, particularly looking at sort of whether or not actually changing behavior by a sanctioned person is going to get any traction in the United States?
Yeah, so look, and Michael, I think you touched upon this. Every program is different, every target is different. It's really on a case-by-case basis. And whenever you're looking at a delisting, in certain contexts, like in a counter narcotics designation, or if the designation is linked to dealing in Iranian origin oil and the IRGC, there might be a basis to go to the Department of Justice and see if there's an investigation or prosecution for which cooperation could be provided. But it's not a one-size-fits-all solution. And I think one of the areas that parties seeking delisting get caught up on is the quasi-criminal nature of the allegations as opposed to what they are actually being designated for. And if you're going to DOJ, and I'm saying this kind of as a defense lawyer with my defense lawyer hat on, really the Department of Justice has traditionally been investigating and prosecuting crimes, at least in this context. If you don't have information regarding crimes, there's not much use going into the Department of Justice. Now, what I would say there is the Department of Justice has been more willing, in my experience, and other departments or agencies to speak with parties, and that's to Andrew's point about having those conversations with the quote unquote bad guys and developing information that could lead to the investigation and prosecution of others. With respect to change in circumstances, I think there's a couple things that are really important here. One, status-based designations versus conduct-based designations. So parties designated for being an official of Russian financial institution, that's a status-based designation. That's clear-cut. You leave the bank and you should have a solid basis for delisting. Although, of course, the legal authorities are now written, they weren't always written like this, to say to serve or have acted. And so there's this past tense. But really, I think what the most disturbing point about this change in circumstances and where there's kind of a disconnect between what's being stated as policy and what happens in practice is the fact that you do have past tense designation criteria. And in a recent court decision here in the US, the US District Court said, look, the regulations are permissive. So even if the party does show an insufficient basis for designation or a change in circumstances, all it says is that OFAC may remove the party, not that OFAC must remove the party. So it becomes highly discretionary, which doesn't quite jive with this idea of change in circumstances. So yeah, I mean, look, again, I would go back to every case is going to be treated differently. Everything needs to be looked at on a case-by-case basis. And the ability and necessity to dialogue with other agencies outside of OFAC or State Department, whoever's administering the designation and delisting process, needs to be judged on its own merits.
Okay, great. So as you're mentioning the courts, let's turn to the courts and look at how the courts are dealing with these cases in the 3 different jurisdictions we're focusing on. So Maya, if we can start with the EU, there have been some really quite interesting decisions coming out of the General Court over the last 6 to 9 months. So are you noticing any particular patterns?
Yes. So just to say, I think we're going to spend about 5 minutes or so doing a very quick whirlwind tour of the courts, because we're getting some very interesting questions in, and I'm happy to fire those in the last sort of 5 minutes or so. So very briefly, the EU story, because it's an interesting one. So about sort of 20 years ago now, there were the earliest EU cases on sanctions. So there's a lot of EU history, and those were the sort of post 9/11 terrorist sanctions listings. And it's interesting to look back now, because I think the EU really has been on a journey, in the sense that back then there were no reasons at all given for listings, and there was no evidence really at all to support those listings. There were then a series of cases brought by the People's Mujahideen of Iran, the MEK, where the European Court first basically said, if you're going to subject people to a restrictive measure, then you have to respect in the EU sort of basic standards of due process, give them evidence, give them a chance to make their views known, and so on. That was then applied in a UN context in the famous Casebycase. There were then hundreds of cases where a number of parties were delisted. And I think it's not an exaggeration to say that the future of targeted or smart sanctions was put into doubt, because I think it felt like, you know, everyone who brought a challenge won them. I think what Eric has just said, and some of our questions are about this difference between status-based and sort of misconduct-based sanctions, is important, because fast forwarding to now, the position in a nutshell is there are some cases where applicants are delisted in the court, but basically the standards of due process are now higher. So there is, as a matter of course, at least some reasoning and some evidence. But really crucially, the criteria on which people are designated are now much more often because of their status or former status, rather than because of their misconduct. And that, of course, makes it by definition harder to challenge cases in court. And also the European Court has upheld the practice of relisting people who have won their cases with slightly different reasons. So just to end then, on the recent Russia judgments, I think, you know, that position is basically reflected. So there have been a few cases where Russian individuals have had some success, but that is what I would describe as being the outliers. So, for example, recently, Friedman and Arvin won a case relating to the previous designation criteria, which are more conduct-based, you know, in ties to President Putin. But what they haven't done yet is been able to challenge their status as a sort of leading business person involved in a sector of the Russian economy, which is obviously a much harder thing to do. Similarly, the European Court have said in cases brought by Violeta Prigozhin, Nikita Mazepin, that just being related to someone in a family relationship is not enough of an association. The UK has dealt with that by legislating to specifically make being a certain kind of family member enough to keep you designated, and cases about whether past positions are enough. So overall, what is interesting is there is a dialogue between the courts and the legislature. I mean, you could call it a dialogue, but the legislatures, I think, around the world have responded to judicial action by what you could call making life easier for themselves, or you could call it, you know, expanding the basis on which people can be designated. But it's certainly, I think, overall got harder to challenge them in court.
Brilliant. So you're right, there are some really interesting questions coming in. So perhaps we can all just give a very brief overview of where things are. Malcolm, in the UK, I mean, obviously the leading case I think that's gone to the Court of Appeal is the Schwidler case. What would you say are the kind of main takeaways from the Court of Appeal judgment, and how that might impact on other cases?
Yeah, so I think you're absolutely right. The Schwidler-Dalston case, two linked appeals in the Court of Appeal. That's if you need to know anything about the approach of the courts, that's what you need to read. I think there are three key features. The first is that the court is giving a broad reading to what are already very broad designation criteria. which itself makes it difficult to establish that you're outside the class of individuals who are in principle capable of being designated. The second, and this really isn't a reflection on the court's approach. This is just a feature of the English standard of procedure, is that what Parliament has prescribed by way of a standard of proof is very low. All it says is the Secretary of State needs to have reasonable grounds to suspect that you fall within one of the very broad categories that render you liable for designation. So that is an extremely low threshold. It's equivalent to what a police officer is required to arrest you for a crime, much lower than anything a court, civil or criminal, would use to make a finding of fact. And then the court itself is going to be one step removed from that, because it will only interfere if it can conclude that the Secretary of State acted irrationally by reaching that reasonable ground. So you've sort of got double reasonableness, which means it's going in practice to be extremely difficult to demonstrate the Secretary of State couldn't reasonably have suspected that you were within one of these categories. And then the third key feature is that there's just considerable deference that's given to the government's assessment of whether it's appropriate to make a designation. Two sort of standout examples of that are that, first of all, the court said that there's no need for the government to demonstrate that an individual designation might rationally make some form of a difference or contribution to the aims of the regulation. You just look at the run of sanctions designations as a whole and assess whether that might make a difference. And then the second is that there's effectively an assumption that's articulated by the court that if you fit within those very broad designation criteria, you should, in the language that the Court of Appeal used, pay a heavy price for in respect of the conduct that, as you said, Michael, could have been perfectly lawful at the time, but which, applying the benefit of hindsight, might have contributed to the ability of Russia to continue its actions in Ukraine. So that's in a nutshell what the court's done. It's considerable deference to the government, I think, is probably the key takeaway.
So we have considerable deference, and Eric says in the United States they have extreme deference. It sounds to me as though that's
might be English understatement. They probably amount to the same thing.
I think that's probably right. We've got a few minutes left for questions. I think, Maya, you're going to be the ringmaster on the questions.
Yeah, well, I just wanted to start with one for you, Michael, actually, which is a really interesting one, which is, what does your firm do to verify information that you are submitting to agencies, which I think is a really interesting question. So I suspect that the government might think it's all very well, all these representations and requests for meetings, but how do we know that what you're saying is accurate? Is there a sort of answer to that question?
Well, I think the answer to the question is that we're essentially, our spinal cord of our firm is we're a criminal law firm. And when you're a criminal law firm, as we've been for 80 odd years, you don't make representations to the prosecutors or to the government unless you're pretty clear that what you're saying you can corroborate in some way, shape, or form, and there's a firm evidential foundation for doing it. So if you take, for an example, the case that Malcolm and we did, which resulted in a delisting, we provided the government in that case with sworn evidence in the form of witness statements, not just something from the actual client themselves, but from proper witnesses to particular events or people who could speak about facts which were directly relevant to what the government was saying was the justification for the listing. So the simple answer is you need to be able to provide a pretty firm evidential basis that is going to withstand any further sort of scrutiny or challenge by the government in due course.
Okay. Very helpful. Now, Eric, stand by for some quick-fire US legal questions, and Andrew. So first one, which is sort of about the court cases that we've been talking about. And I mean, Malcolm talks about the reasonableness and deferential standards of the UK courts. I mean, my understanding is that the US courts are, if anything, even more deferential. And there is, I think you mentioned it, the sort of Chevron agency sort of degree of deference. Now, one thing you've been asked is if that is overturned in the case currently before the Supreme Court, would that result in a wave of legal challenges in the US, or is that sort of not realistically going to happen?
So some sanctions practitioners have made that argument. I haven't seen it in our cases that much. Chevron hasn't necessarily needed to be relied upon, because what it has been is not necessarily whether or not the agency has deference on the scope of its authorities or how they promulgate those authorities, but rather or not whether their agency action draws that rational connection between the evidence and the decision made. So I actually don't think it's going to impact the jurisprudence, even if Chevron is overturned. As a general point, it might be relevant in certain cases where certain arguments are being presented. I don't know if Andrew has a different take.
No, I agree entirely. It doesn't mean that there won't be a wave of litigation, but it seems very unlikely that those cases will be successful under a Chevron attack.
And then I guess for either of you, really, a couple of questions about interactions with the government. So I think Eric mentioned that offering sort of mitigation actions as a route to delisting is one thing that happens. And so I suppose the question is, have there been any cases where the government has agreed a plan, as it were, as a route to delisting based on those sorts of mitigations? And a related question is that, in an unusual case, perhaps it's unusual, where the US agency invite someone for an interview to clarify something. If that's, a designated person, is that person then given a license to travel to the US to do this in person, or how does that work? Does it happen in another country? So Andrew, I don't know if you want to have a go at those, or.
Sure. So I'll take the second one first. Certainly, there have been instances where people have sat down at the government with listed people. It is possible to come into the United States. It's possible to get a license to do that. It's possible to get a license to the attorneys or to the airlines, et cetera, to make it happen. It's not easy, but it is possible. Often, however, it is the appearance of coming to the United States or the appearance of getting on a plane to a Western country, and certainly in the Russian context, that precludes that from happening. And in those instances, you often see prosecutors or US regulatory lawyers getting on the planes themselves to go meet elsewhere. So yes, possible, not easy. And I'll defer to Eric on the delisting. I think the quick answer is yes, there have been delistings in part based on mitigation, often in the form of just divestment from corporations. But those are the ones that jump off the page to me as the examples. But Eric may have others to offer.
Sure, yeah. So the meetings typically, at least in the OFAC delisting context, happen in third country embassies. So neither in the United States nor in the home jurisdiction of the targeted party. But some regional embassy, particularly if OFAC has an attaché in that embassy. With respect to the first question, I obviously only know from my own experience, which I think is pretty broad in this area, but I would say since 2017, the majority of parties who we've removed from the list that has been pursuant to some remediation plan that was proposed to the Treasury Department and accepted as a basis for the delisting. So it's becoming more and more common for a party to make those remedial measures, enter into an agreement that those will satisfy the basis of the designation and warrant a removal. And then once Treasury has the evidence that those measures have been carried out, at least to a certain extent, and that evidence is credible, then they'll agree to delist. So most cases are resolved that way these days.
Okay, so one final question. is about the possibility of securing damages from authorities given the sort of impact of sanctions. I mean, the short answer is in the EU, it's virtually impossible to get damages against the authorities, although again, there are a couple of outliers. Malcolm, I don't know if you want one final word on that possibility or lack thereof in the UK, and Eric in the US, and then I think we do have to wind up.
So the position on the face of the legislation in the UK is only in cases of bad faith can you get damages, and then there's a cap on those damages, which is set at a very low level. But that might not be the end of the story, because there have been suggestions, including by judges, that if damages were required to remedy a breach of human rights law, the position might be different, but that's yet to be determined. So possible, difficult argument. Watch the space, I think, is the best I can do.
Yeah, and on the US side, the answer is pretty unequivocally no. Most challenges are brought under the Administrative Procedure Act, which only provides that the relief available is injunctive relief, no damages against the government. There are some theories that you could pursue an action under this case Bivens v. 6 unidentified FBI agents. I've never seen it deployed successfully in the sanctions context. I've never been comfortable bringing such a claim. I just think it's kind of a non-starter in the US.
Okay, well, thank you all very much. We're slightly over time, but it's been a tremendously interesting discussion. So Andrew, Eric, Malcolm, Maya, thanks very much indeed. No doubt we will do this again at some point in the future. Many thanks to all of you watching as well. I hope you found it useful.